My name is Colleen Mullen. I am the Director of Pro Bono and Volunteer Engagement at Legal Services of North Florida, it's a private, not-for-profit legal services organization. And what we do is we try and fulfill needs in the community, legal needs in the community. One of the ways we do that is by outreach clinics, such as the one we're doing today. So this is an informational clinic where we're going to have Sean Desmond come up, and I will introduce him in a minute. Come up and talk to you about why wills are important, why you should have a will, and what specifically it helps protect. And so the reason I ask that you fill out those green sheets is to ensure that the next steps we can continue to do, because we have very specific restrictions on our funding and our what clients we're allowed to serve. We do need those green sheets to be filled out in order to fill out a will for you. However, even if we have difficulty accepting you as clients, we will try and refer out your cases anyway and get you the legal help you need. So that's the goal behind these presentations. And the first one tonight is informational. The second clinic that we're going to do is where we have you all come back, and we will take those documents, the second, third, fourth documents that I had you all pick up, the white sheets. Once you fill those out, get those back to us, we will draft wills up. And then the second clinic, we will have you come back and sign your wills, because in Florida, there are very specific, strict rules about what makes a will valid, basically. So without further ado, I'm going to introduce attorney extraordinaire, Sean Desmond. He is a former prosecutor, former criminal defense attorney. Are you still doing criminal defense cases? I didn't think so. Which is where I met him. I was a public defender a million years ago. And so he is an old friend, but someone I know is a fantastic attorney and a really, really knowledgeable one. And he has agreed to give his time tonight free. And I think this is going to be a really beneficial presentation. So Sean. Oh, and he also ran for state attorney of 2nd Judicial Circuit, which is here and the 5 surrounding counties, and lost by very little.
That's right.
And won Leon County.
That's right. See, I'm happy at least one person remembers.
I do. So if you have any questions, he'll be happy to answer them at the end, and I'm happy to answer any questions about legal services.
So how do I advance this when I want to?
You should be able to either click here.
That's good.
Yeah.
Okay. Well, hello, everyone. Hello. How's everybody doing? So that's the best picture I ever took. And so I'm going to keep using it. That's about, yeah, that was in my younger days. So yeah, no, I've been practicing law right here in Tallahassee for about 21 years. I came here to Tallahassee to go to law school, and I did not intend to stay in Tallahassee at the time, but then I met my wife, and she was in law school with me. And I see my good friend Letitia back here, who also knows my wife. There's something when you meet that person that's going to change everything, isn't there? So that pretty much set me straight, and that's why I'm here in Tallahassee, and we have no intention of leaving. Just a brief kind of give you an idea. I started off as a trial lawyer, as Colleen was saying. I did all the things in court, so I saw lots and lots of stuff.
Oh, Sean, there's a microphone, which I assumed as former litigators, you and I would not.
Do they need it for the webinar?
No.
Okay. I don't. Can you hear me? Because I'm pretty loud. All right. So what I was telling you is essentially I started off trying cases and was in the courthouse the whole time. And I ran for public office trying to figure out what I was being called to do, that kind of thing. And around about maybe 2014, my dad came down with dementia. All right. And it started off real slow. Just started getting forgetful, kind of like driving around, and had to call home and how do I get home? How do I do this? I don't know if you've ever experienced this before. We started to see that and started to kind of, our eyes got a little wider. And so I watched him, he was in Orlando. So I was the lawyer in the family. So I started to read about elder law and estate planning and all that, and started to get really passionate about that. We walked with my dad through that entire thing. And it's progressive, as you know. And so when it got to the final stages, we walked through that whole process with him. And I started to learn a lot about what happens when we get to that point, and how wills work and trusts and powers of attorneys and living wills and all that stuff that you hear. Even as a litigator, I heard and said, I don't know what that is, okay? Because it's a different side of the law. And then my mom, at the same time, she had the exact opposite situation. She was physically suffering and getting worse, and she kind of got congestive heart failure, but then also diabetes, and it was like the trifecta. But her mind was as clear as a bell. And so we dealt with that side of the equation too. And there's lots of questions with that for long-term care and how you're going to pay for that, and versus how you protect assets. Make sure that the money you work hard to earn doesn't just evaporate, and we want to make sure that we try to help our families, right? That sort of thing. So that's kind of what led me into the area. And when I actually, after my election, which thank you for remembering, I did win Leon County and I won Gaston County, and all the little counties outside here ganged up on me. And we had 60,000 plus votes. If we had 861 more, I won. So it was that close. It was like a percentage point, but that basically, I like to say I was elected to private practice. All right. So after that, I went to the environmental protection. That's where I met my friend with teachers back there. So that's a little bit about me. What I wanted to talk about, though, and I entitled this, I can get there, figure this out. We're not known for our prowess with.
No, all of us struggle with technology.
Yeah, how do I move it here? Should just be that, right? Okay.
There you go.
All right. So if you bear with me, I usually get there. Okay. So the first question is why people need wills. Right? That's the title of the program today. Does anyone know what a will is? Tell me what you know. Okay. It's giving them a voice. Okay. Does anyone know what a probate case is? Anyone know what's a probate?
Basically a case when a lot of times the banks ask you for that information. To start a probate case, it's basically anything. It's you're using the final judgment from a judge to state that you are entitled to whatever is in the will or whatever that person is trying to do.
Okay. So basic, and you nailed it on the head that you got to get to court. All right. So a will, so what happens if you die without a will? Anyone know? The statute will actually, the Florida statutes will actually still divide your property. So if you don't have a will, you're gonna, and you have stuff that, and this is very, very important. Probate only deals with property that's in your name only when you die. So if you've ever been married and you own a house and it says on the deed, husband and wife, okay? What happens when the first spouse passes away? It goes without going to court, without any other reason, it goes straight to the other spouse. And in fact, all you got to do, if you ever wanted to sell that property, is get a copy of the death certificate and record the death certificate, and that property is yours. So what I see a lot of times with couples, when married couples come in, there's two of them, and the first one to pass away, we don't usually have to open a probate. We don't have to pull out the will. Because nine times out of 10, that married couple owns things jointly. And if they own it together as one couple and their joint ownership, the one passes away, there's no need to pull out your will. There's no need to go to court. It's the second spouse that passes away. Now we have to, what happens? You have the house is typically owned at that point in that person's name alone. Okay. The bank accounts and all this other stuff. So if you were to die like that without a will, we'd look at the statute in the law. And the law would say, all right, we're going to divide it up, but it might not go exactly how you want. Okay. The other thing about having a will is you get to pick who's going to be the administrator. We call it the personal representative or the executive. Yeah, anyone here have kids? How many? 3? Anyone have more than 3? 2, 1? How many? 5. Okay. How many? 5. I have 3. It's me and 2 sisters, and my parents picked me to be the personal representative because I was the lawyer. We got one who's the medical person, and one's like an administrator, but neither one of them would want to do the executive stuff. But every now and then, people that are not qualified for the job want to do it anyway. And so when you put that 5 people, there's no will, the 5 people come in. I want to be the person representative because they think they're going to have some kind of sway over things sometimes. And they do have a lot of power. So it's important for you to be thinking about who's the person or people that you want to be in charge of administrating this thing. We have 2 kids, a boy and a girl. We call one our yellow lab, and one's our Jack Russell Terrier. The Jack Russell Terrier jumps up with that nonstop all the time, running around crazy all the time. The yellow lab sits down, takes a nice long nap. You know, we love the differences in them, and we know that if it came down to it right now, I'd pick the yellow lab. He would be our executive. Why? Because he's very methodical. He's very. You just want to be thinking about the personality types, you know, what's going on there when you pick who's going to be your personal representative. That's a major component to why you want to have a will. Because when that will gets put in front of the judge, unless there's some reason why that person can't serve, like a legal reason, like they've done something, they're in jail or something like that, they're going to get great preference by the judge to get the deal. Okay. What other reasons would you want to have a will? Let's see if I can get here. Okay, we talked about the first one. The will and testament is a document that tells the court what you want to do with your property. Now, this is a great point. If you have a different idea about what some of your property needs to happen with it, you better have a will. Because the court's just going to say it's divided equally. But you may not want it to go that way. You may want, for other reasons, you may during your life have helped out one child already. I see this all the time. Well, you know, Junior got that 5 acres already because they needed it earlier, whatever. Well, if you do nothing about this in the will, that what's remaining is going to get divided by 4 or 5 or whatever left. And so that one who's already gotten some is going to get another chunk. But the other ones are going to go, what happened? Right? All right. So that's important because it gets to tell, basically you're getting to tell the court what you want done. And it also helps avoid the fighting amongst the siblings. Okay. The next one here, a probate case needs to be open where the will must be proved to be authentic and original. That's what Colleen was talking about. You have to have a will. When you do the will, you got to make sure it's done by the statute. You have to sign it in front of 2 witnesses. It's really good if you have it notarized because that helps avoid needing to call witnesses later to prove it's the real deal. You also have to initial every little page, and there's all these little rules, and that's what they know how to do. So you want, and we'll find people that know how to do that, right?
Yes, and we do. We have a bunch of pro bono attorneys who are really happy to do this work. They love it. And you can tell from how passionate Mr. Desmond is, it is good work.
Oh, yeah. No, so that's critical. So when you get through this, don't just take it home and put it under the mattress or whatever. Come back and follow through with it, okay? Because you can't just write it down. I've seen people try to write it down on a notepad and say, this is what I want to happen. That's not going to fly. So you need to make sure you do go through with it. I talked about the court will appoint the personal representative. That's important. I already talked about you do not need to have a will, but it's a very good idea to have. And all that means is, again, your stuff is going to be divided by the court one way or the other if you don't have a will, but you sure want to make sure you're telling what you want to have happen. Like you said in the beginning, you want a voice, and that's important, okay? We talked about that one there. Okay, so let's see if we keep going here. All right, this one here, do all your assets get handled by the will and the probate court? Let me ask that question, Joe. Well, you got the answer in the first one. So why is that? The only assets that the court addresses are ones that are in your name only. All right, I get this all the time in my practice, okay? Elderly parent comes in, they've been having a tough time getting to do what they used to do easy, right? They need a little more help, so a lot of times I hear this, there's one child that's around, that lives near, and then maybe the two of the other ones are around, but not as close and not as involved. And there's good reasons. So-and-so might be working at a real good job and just doesn't have the time to come and help as much as the one child, right? This is family dynamics. It happens all the time. Happened in my own family. What does mom do? She doesn't talk to an attorney. She puts the oldest child or the child who's nearest on the bank account. Why? Why? To help make things easy, to cut the checks that she needs. Mom can't get out as much. So oldest daughter, who is a trustworthy person, okay? We're not, this is very important. But what happens when mom passes away? And the name on the account, whose name is it now in? The child. You want to see something that's going to tear some family members apart? That's it. And it's the number one mistake I see people make, day in, day out. So you want to be really careful about how you do that. Okay? You can do it with alternative ways. You've got to figure out a way. Unless you have one child and everything's going to that one child, it's probably not a big deal. But if you have multiple children, you think that all your stuff is going to be divided equally. Well, really what ends up happening is your house is your major thing, and then your accounts. Well, guess what? All that money that was in those accounts just went to child over here. The other two kids come over and say, hey, what about our share? And this comment from this one is, where were you at 2 a.m. when I was taking mom to the hospital? Right? I hear that all the time, and now they're not talking to me. So that's why we talk about why it's important to do some legacy planning. So this is a little bit beyond the scope of our discussion here, but there are other ways to do this, and you can use trusts as well. But that's it, more a little advanced. The bottom line for this presentation is make sure you get a will, but don't be blind to the issue at hand. Just because you have something in a document that says, hey, divide this equally amongst everybody, does not mean that's what's going to happen if you have your names on bank accounts that they just inherit. Okay? It might work out where that child gives over the money, no one ever fights about it. But you want to allow that, you don't want to allow that temptation. Okay? Any questions about that? All right. This one here is the same point. Property owned jointly with rights of survivorship bypass court and go straight to the other person. I already talked about this husband and wife situation, so let's keep going here. Talked about the bank accounts. Also, huge point. The number 2 bullet point. Anyone have an IRA or a pension with the state? Okay. You work your whole life. A lot of times, if you have the investment account, you'll have a big account sitting there. A lot of people put money away out of their paycheck into IRA funds, right? Well, that money accumulates tax-free. And people are very surprised when they pick up their head at the end of their career and go, wow, I got a lot of money there. Now that's designed to help you live on, right? That's your retirement for that income stream when you get older. But that is not, if at the end, at the bottom of that paperwork, it says where that money is going to go. It's called a beneficiary designation form. If you're not careful, that could be messed up too. So you got to know that if you're one of your largest assets, as long as if it has a pay on death, a beneficiary designation, same thing. That means it's not going to court. If you name an individual, it's going straight to those individuals. Does that make sense? Okay. Sometimes you may want that because not to go through probate. So I'm not giving probate a bad name because probate is an important thing. But probate is also very easy and public for people to file claims, particularly Medicaid liens. So if somebody gets Medicaid benefits later and a Medicaid lien is accumulating, and where can they, when the person passes away, where do they actually go to try to collect? They file a statement of claim in the probate case. So sometimes it's nice to be able to have assets passing outside probate, but you've got to be careful, again, to make sure it coordinates with your plan. So that's just very important. Great example could be, you leave one child, one on there, who knows? You just have different things change, or something in your life changed. Maybe the person who was supposed to inherit that money on your beneficiary designation form passed away, but you never remembered to change it. Now, what's happening? That's going into a probate for that person, and that may not kick automatically to where you want it to go. So just be careful about that too. All right, that's wills. Before I move into powers of attorney, any questions about wills? Did that confuse anybody? Okay. You want me to talk a little bit about it for us? You got a question?
How often do you have to update your will?
Well, I see people come in to see me that the last time they looked at their wills was in the 90s. And some people don't have a will at all. I will tell you that it's good to have it looked at and updated, once every 5 years, probably. Because just like everything else, there's the standard of care of what the legal profession does and what they cumulatively have discovered is the best way of doing things. Changes, we improve. And so you add different language, so you're looking at things that may have been relevant back in the 90s that is not relevant today, and things that are more relevant now today. If you have a special needs child, what I mean by that is if one of your children or someone you want to send money down to is disabled and getting benefits, SSI, Medicaid, you want to make sure that the folks over there know that, and make sure if they don't know how to do that type of planning, you call me. Okay, because we add special needs trust language into wills when needed in those circumstances. So that's important to be kind of looking out for. Okay, but that's a great example of something that when I started practicing law, 2000, no one put that type of language in wills. It just wasn't, but as time has gone on, it's kind of becoming more of the norm. So you do want to check on that. Tax laws change. We're about to see, I don't know if anything's actually going to change, but they're trying to change everything right now. So that's a great question. It's not on my agenda. Go ahead.
Okay, so you talked about having multiple children and the battle that can go on, but if you're an only child, do you still have to, specify that you're like the power of attorney and all this stuff in the will and stuff like that?
Yeah, I mean, I would anyway. I mean, I think it makes things so much easier because if you ever go to open up a probate case, just to give you an example of how a probate works, you got to go to the court clerk. You can get a lawyer and a lawyer will handle it for you. But if you do it yourself, you got to go down there and fill out the petition, pay the filing fee, which right now is $400. Okay, you file it. Now they may be able to waive that if you can fill out a form for indigency and all that. But you pay the money or you get the file open. Okay. Then if you have the name of the personal representative listed in the will, that's going to save you a hearing. You know what I mean? In other words, if you're the only child and they're going to grant you the request to be the personal representative. I don't have any doubt about that, but they're not going to do it without a hearing. So now you have to set it for you. It just slows things down. Probate doesn't move quick. That's one of the biggest complaints I always get about probate is you're dealing with judges and dockets, and anyone who's in the legal world right now knows those courts are like backed up like you've never seen before in the history of courts. So anything you can do to speed that up will help you. And then it just makes it clear that you're the person and it gets you your letters of administration quicker. And that's what they're going to do. The court is going to ultimately give you a document called letters of administration. And that's your legal document that you take to the banks and take everywhere. It's like the court authorizing you to be the person. It's just legalese for here's an order of the court. Great question, though. Any other questions? Does anyone in this room want me to talk briefly about trusts? A little bit more, they're not going to do that necessarily, but you probably are going to hear a lot out there about trusts, okay? A revocable living trust is just an alternative way to hold your stuff that avoids probate. And it avoids liens potentially. So I don't know if they touch trusts over there. If anyone, now you don't necessarily need that, but if your circumstances are a little more complex, okay, get with them and find out, and then you can come see me and I'll talk to you about that. Okay, but
Or if you're specifically only a dog parent and you want to have a trust that you want to make sure money is left to take care of your animals, can't do that through a will.
you can, right, yes, exactly. So you want to, if you want continuing oversight over things, that's a more effective way to do it with a trust. Basically, a trust is just a contract between you as the one, it's called the grantor, you're the one giving your stuff to yourself as trustee. So it's a contract between you as the gifter and you as the overseer. Simple as that, but there's a long document that lays out all the rules. The beauty of it is if you get sick, then a successor trustee can step in without having to go to court, and they can do things without having, you don't have to go open a guardianship. If you're incapacitated, you don't have to open a probate. And like Colin was saying, if you have more advanced planning that you want to do, like you can add a pet trust. This is done quite a bit. You can do a pet trust. You can lay out things. You might have 3 kids. Now, I will say this. One of the other advantages of a will and a trust, but also a will, is if you have children that you want to establish some form of a trust for, you can do that in the body of a will. That might be outside of the scope of what they're going to do over at Legal Aid or North Florida Legal Services, but you may need extra type of planning for them, okay? Just know that you can do stuff like that. What I mean by that is you got 3 kids, one's a doctor and is doing great, one's an engineer, and one is just kind of trying to find themselves and they're struggling artists. Okay? All right, and whatever. I had one dentist, all right, he came in, he had a 42-year-old son, and the dentist had, you know how dentists, they just make money. That's all they do, sit around and make money. And he had this one son and he knew the son would blow the money immediately. You know? And so he said, I said, well, what does he do for a living? Because he plays video games every day. Okay, well, that's not going to work, right? So he set up where he would get an income stream. He set someone else to be the trustee over him. He got an income stream to make sure he didn't blow money. But then at intervals of 5 years after he died, then another 5, and then another 5, then he'd get the money. So he would not blow it all at one time, and maybe learn how to use money. You don't have to do it by 5-year period. You could do it by age. You could say, you might have younger children. Well, you have a life insurance policy just because you work for the state. A lot of you do. And that money and all this stuff is going to come in. You might have minor children. Well, you don't want to throw $500,000. Let's say they now have 19. Do you want $500,000 to go to your 19-year-old son? I don't. First day my son was driving his truck. Very first day, we drove every single day to the gym. I made him drive me on that permit. You know, we'd leave the gym. Oh, this is great. You're learning how to drive. He does his first solo drive, goes to the same exact place, comes out, gets in a wreck. We're getting dropped. Our insurance coming in. I don't want my 19-year-old son getting the proceeds of a life insurance policy. Now, even if it's, the life insurance, if you work for the state, they multiply that by like 5 or something, maybe even more. That's a good chunk of change for a 19-year-old. If you put in your will that you want a trust set up for those kids so that they don't get maybe the first 25% at age 25, the next 25% or maybe 50% of what's left at 30, and then the other remaining at 35. You can do that to help save them from themselves. Okay? So that's just some of the things you can do in a trust. Now, the will can be created to have a trust built in it, but the trust is then created by the will. And then the court may have some oversight over that. That's another reason why doing a separate trust, a pre-existing one, keeps the court out of your business. Okay? So, did you have a question, Letitia?
So that trustee, who will be the actual trustee? Will it be a court-appointed trustee or will it actually?
So if we're in the revocable living trust realm, when you're talking about, I'm going to do a will or a trust right now, what am I doing? You're going to be the trustee of your own trust. Does that make sense? Okay. Now, who do you want to be if you were just doing a will, who would you have as to be your personal representative? Typically, that's the same person you're going to want to have be the trustee. Sometimes, because the personal representative is usually does their one job and doesn't last forever. So you may not want to have the same person. But a trustee would be somebody that you trust to handle and follow the instructions of your document. What's nice about not just giving money to people is when you put it in a trust or it comes in a trust that gets formed by a will, there's fiduciary responsibility over that. So they have the authorization to use the money, but they can't just take it to the deed without getting in trouble. Okay. So does that answer that? Yeah. You can do multiple successors as well. You can do co-trustees or co-personal representatives on a will. So you can do that. You might have 2 kids that you don't want to offend one of them. The one is not going to do anything anyway, so you just name them both. And you say, either one's going to be able to act, but they can do it independently. You don't have to have a signature from the other. So that's important. Those are some of the tools. Okay. So I don't want to take us too far down the trust road, but I did want to kind of let you know about that as an alternative mechanism for planning if you choose to do that. I will say this, the thing about a trust is you have to fund your assets into the trust. What does that mean? I have to take my home and do the deed again and retype the deed and record it again, this time saying that it's in my name, but I'm giving it from my name to myself as trustee of my trust and record that deed. We'll change the bank accounts. And so you get everything into the trust. That's how that works. Okay. All right. Any questions about that before I move on? Yep.
You were saying like the insurance, that we have, and if you take, and you have it designated for 50% to go to this person, and then the 25% to the other two. I can say with the state that I want it to go to them at a certain age.
No,
I can't do that.
there's limits on what you can do on a beneficiary designation form.
Mhm.
They're just they're a bureaucratic machine. They just want to know, okay, what do we do with this money? We're not going to keep on administrating and looking over your shoulder. What you do is, instead of leaving it, you could say, I want this all to go to my trust. Does that make sense?
Oh, yeah.
So instead of 50 to junior, 50 to, you send it, say, into my trust. And then it goes in there, and the trust can divide it out, and you can have all kinds of different protections and all that. Okay? All right. Anyone? Okay. Power of attorney. Anyone know about a power of attorney? What's that mean?
When someone is over handling your business, they can take and pay all your bills and do everything, but from my understanding, it's only good until a person dies.
Correct. Correct. Okay, so to repeat that, a power of attorney is a document that says, and this is another document that I'm certain that they can prepare over there, help you prepare. Okay. Everybody should have a power of attorney. What that means is I'm giving over, like I would have my spouse in the event that I was incapacitated. This isn't death. This is when you're laid up. This is when you could be conscious, but you can't go anywhere. You could be in the hospital recovering from surgery or recovering from an accident, and you don't want to be, you can't get out there to go to the bank, but the bank wants to see you. So you send them down there with a power of attorney that says, hey, this is my authorization that this person can do business on my behalf. Okay. Very important document. 100% get that executed. So that's what a power of attorney is. I'll briefly, I don't even know if I have it in this slide here, but I'll briefly tell you about, before I even get there, don't read that. Healthcare documents. Okay. I don't know if they're doing them. You doing the healthcare documents?
The healthcare surrogate,
Yes.
well, yes.
Good. Vital information as well. I will tell you this, my experience is once you cross over the threshold into a hospital, then when I'm here working in the medical profession, once you cross over that threshold into the hospital, it's a different world. It's just they work on a different schedule, different mindset. They have a whole different world of it. And it can be very, very daunting and confusing sometimes. The healthcare surrogate is just a document that allows your loved one, usually it can be the same person as your personal representative, to act on behalf of you if you cannot make a medical decision. So if you're in the hospital, you're unconscious, the doctor comes out and says, look, she ain't gonna make it unless we do this surgery, but there's only 50% chance she's gonna make it with that. The obvious answer is do it, but they don't wanna make that decision on their own because they're worried about this and that. They need a person that can step up, which is why typically we try to name one surrogate. Because the last thing we want is two siblings fighting on the floor of the hospital. Okay, so we typically name one sibling there, or one child to make that decision. If you're married, it's easy, the spouse. And after that, pick somebody. But that's a critical document as well. They can help you compare that. What's a living will? Not to be confused with a living trust. This is one of those areas people get messed up on. What's a living will? And anyone ever heard of Terry Schiavo? Yeah, the lawyer in the room does.
I want to my hand every time he asks a question, because that's what lawyers do.
Yes, I know. Who knows what a living will is? Anybody? Okay. A living will is just a document that says, I don't want to be prolonged on life support forever. We're talking about you're in a permanent vegetative state. You're incurable. All the doctors are basically like, you're not coming back. My experience is that no one in that situation is trying to rush you. Okay. I've not yet been in there saying, hey, you need to go ahead and get her out. I mean, that's not the way the medical field is. I understand all the pressures they face, but typically their heart is to cure and to save and help people, right? So it's not like they're going to pull the plug on you super quick. And the issue that came up in Terry Shavo's case was she had been in a permanent vegetative state for a long time. Well, there was no document saying anything. Parents wanted one thing, the spouse wanted another thing. Who decides? You would think. It turned into a little battle between a little enormous battle where actually the governor's individual police force was like standing in front of local law enforcement. That's how it came. I mean, we're seeing that sort of activity lately, okay? But that's kind of the stuff that happens. So you want to have a living will that says, I don't want to be prolonged unnecessarily. If after a certain, after it looks like I'm not coming back, just give me palliative care and let me go peacefully. Okay. It just saves the fight between family members later if it was going to happen. It's not going to happen much, but once in a while, you want that. Last one is the HIPAA release. I always do for people. All right. So you know what HIPAA is? I can't tell you anything about, you can't tell anyone about anything. Okay. But if it's involving medical, it's all private information. Well, what happens when daughter from out of town comes in freaking out because mom, where's mom? Comes to the door of the hospital and wants to know where mom is. Well, who are you? What authorization do you have? Or best friend from childhood. Who's not a family? No, that's why. Are you family? I'm just about. Well, you ain't family. I can't tell you anything. And you get the bureaucratic red tape. You want a document that says, I hereby give the fund. You can put really as many people as you want. You can put my entire Sunday school class. There it is. Off you go. And so you just want to have that there to be able to do that. Okay. All right. That is the rest of my discussion would be, if we got there, I could go on and on about asset protection, long-term care stuff, but I'm going to take my cue from Colleen. So.
Well, it is 7 p.m. and I don't know about y'all, but I get real hungry and then I get real hangry and it's not a pretty picture. So we're going to wrap this up pretty quickly. These documents that we handed out earlier, the green sheet again is, and for those of you who came in after I spoke, the green sheet is to apply to be a Legal Services of North Florida client so that we can provide legal assistance to make the wills, powers of attorney, and healthcare surrogate and living will. We do all 4. We do not do trusts, unfortunately. But these documents that we handed out and said you guys can hold on to them for now. We will eventually want them. But these documents is so that you can start thinking about who you want to designate as your personal representative. I know a lot of you said you have children. Some of you have children who are still under the age of 18. You probably don't want to name them as your personal representative. Some of you don't have children. And so you've got to think about who you want to name as your personal representative, who you want to be a beneficiary in your will, things like that. So these are fairly straightforward, but if you have questions, we are always happy to answer them. The power of attorney document, that's asking you who you want to handle your affairs if you are not able to, but you are still alive. And the last one is the living will and healthcare surrogate, and ask questions like, who you want to be your healthcare surrogate and who you want to know of the healthcare surrogate. So say you name your best friend from your entire childhood as your healthcare surrogate because she's a nurse and she knows everything about what you want to do in regards to your health. You can list out that your kids already know she's your healthcare surrogate and make sure to tell your kids that. So those are the big questions that we want to be asking. Also for the living will designation, we need to know if you do want a living will, if you do want that document saying if you are on life support in a permanent vegetative state, whether or not you want them to discontinue that life support. And there are a couple of other questions if you're not in a permanent vegetative state, but they've deemed that you are not going to improve, things like that. So those are questions you need to start thinking about, and we will be asking you when we make the wills. And we try and do all the documents at once so that they're all signed by the same people, they're all signed and notarized at the same time so that there is no question later on about whether or not it's a legal document. As Sean mentioned, if it's not a legal document, we can't use it. So that's why we do that. So if you have any questions about these worksheets, I'm happy to answer them, or any questions about legal services, I'm happy to answer them. If you have any further questions for Mr. Desmond about elder law or creation of wills or trusts or powers of attorney, he is going to be standing by for at least the next 10 minutes.
Yeah.
All right. And please let me know if you have any questions right now. And this
Y'all
is
know.
Antoine. If you don't know him,
They all know.
yeah.
So I just want to say, like, I'm super excited to see you guys all here. This is really, really, really important. Just as important as getting into your home is making sure you're able to keep your home in your family. So we talk about wealth creation, all that stuff y'all had to do to get your house, right? And all the stuff you're doing while you're in your house. And if you thought it was just going to go to the kids, or you don't want it to go to the kids, you know, this is how you do that. So it's super exciting to see you guys all here. Make sure you follow up. It's going to be just as big as, you know, getting in the house, a little bit of paperwork, but well worth it in the end. The only other thing I'd add, which maybe you guys said already, and I apologize for coming late, make sure you got multiple copies. Make sure your will is in several hands of several people.
And keep the original in a very secure place. Do not put it in the bank in a box, because then the court will have to order the box be opened, and that delays everything. We recommend getting a fireproof box and keeping it in a fireproof box. If you cannot buy one of those fireproof boxes, the best suggestion I've ever heard, and I think it's amazing, is to put it inside a plastic bag and put it inside your freezer, because your freezer is fireproof. So
I
that's,
actually put that in all my letters.
I love it.
I appreciate it.
I love it. I'm sorry. We do keep a copy digitized at Legal Services of North Florida in somebody's file. So yes.
And just let everybody else know where the original is.
Right.
So,
Right.
And I would say, you know, in the last 7 years being executive director, you know, to kind of go to the point of why to do a will versus if you're the only child. In that time between the tragic loss of a loved one and you figuring everything out, we want the mortgage. Electric company wants power to come home, car company, and you legally don't have the right to even call the office and say, how much is mom's mortgage? Like you are not anywhere on that deed or mortgage, you have no legal right. So if you go through the trust or you have the will expedite the process. The trust, depending on how you set it up, could give you that legal authority because now you are the trustee. So you can say, here, I'm here, I'm functioning in this capacity. So you want to make sure you guys can make this easy because it's going to be the worst time of your life. Right? Your mom passed, your dad passed, or your passing, it's gonna be tough for your kids. So make sure you make it easy, make sure you follow up with these guys. And again, I'm super proud of you guys for being here, so it's so awesome to see. And we all in the same room, too. You know, we got masks on, you know.
Yeah, the nightmare scenario for us, and this is something we have seen so many times, so it's not unheard of at all, is we have a hurricane come through and you and your spouse pass away in that hurricane and there's a lot of damage to your house. Whoever inherits your home, they have to have legal title to get FEMA, to do any work on your home. So that could be an asset that just goes kind of out the window if you don't have these legal documents in place.
Or it
So-
goes to the state, or it's sitting there for 6 months, and by the time anybody gets it and figures it out, or can get the money together to afford a lawyer, right?
Right, all true.
You know, the house isn't worth what it was. And like us looking at it in the office, like we see this a million times, like we know y'all. I know you're her son.
Yeah.
But I can't legally give you any of the stuff you're asking for. I can take the money and put it in the account, but I can't tell you how much was in the account. So we just want to make sure you guys are super safe.
And
Homeownership is
encourage
number one
your
wealth creation.
Family and encourage your friends to do
Yeah.
the same.
Exactly.
Yes, ma'am.
I was asking you said about the home, so if you have a will, and say if I pass and I have a will and say you are left to live in that house, you are left to live, all they would have to do is take it to the Habitat office.
That would be helpful, but they're gonna have to go take that to the court. The court, you're gonna go through the full probate
That's what I'm
process.
saying.
Right, but it's gonna take, what, a couple months? Usually.
Yeah,
So-
without a will.
So one of the things, you know, to think about as you guys talk about trust, right now, my grandmother is 80, she just turned 88. And I've got her in a nursing home, and, you know, we are slowly getting to that time. And so the things I gotta do is try to figure out how to put her stuff in the trust. I've already got will, I've got power of attorney. But right now, she's in this state that if I were to sell her house, or if I were to give it to her, my brother, like legally, I'm on the edge of being able to do that, because she's on the edge of actually being able to give me authority to do that. So she's giving me general power of authority, but after she passes, power of authority goes away. I mean, the power of attorney goes away, right?
Yeah.
So
Absolutely.
then we're gonna go to probate. So what we've got to do between now and then is get all of her stuff in the trust. So then we can act. Otherwise, there's a 2 or 3 or 4 or 6 month gap, depending on where you are.
Yeah.
Before you.
So
can
if
do
you
anything.
have a will, they can file that with the court. The court will issue the letters of administration very much more quickly than they ever would with a probate case.
So will to the court.
Yes, and get those letters of administration, and that's what you're gonna want to take to the Habitat office. Correct.
So is it less expensive so if you have a will, you still have to pay court fees and what have you.
Yes,
But if you don't have a will, you're probably gonna have to pay an attorney and work additional court fees. It'll be
and
more
possibly a
expensive.
bond,
And fines?
a bond,
Oh, a bond?
yeah.
And then it's still also
Some
up to the
courts do
judge, too.
require it, not really many here that I've heard of. But some courts do, and it depends on how many assets and the value of the assets in the estate, whether or not they charge that, but they can, and that can hold up the proceedings too.
And with no will, it would also be up to the judge as to what happens with, you know, your.
And for
Yeah,
our
okay.
Zoom participants, I am going to email out all of the documents. I've got all of your emails, so.